speaking today that judges are in a nonpartisan position. They will not be able to stand on the Democratic bandwagon, nor will they be able to comment on pending cases or legal opinions that might come before them. So, nevertheless, I think we're going to find plenty of questions to ask, and you can type in your questions in the chat room of this particular video. But now it is my pleasure to introduce the moderator for this event. It is Judge Monica Purdy. She is educated right here in Texas for law school. She has been an associate judge for the city of Dallas for the county. She was a local counsel for several Fortune 500 companies before coming onto the bench. And she was a partner at the law firm of Lineberger, Garden, Blair, and Sampson. She has been a board member of several entities, including the Dallas Bar Association and also the National Bar Association. And she was president of the J.L. Turner Legal Association. In addition to all that and raising 2 kids, she has also found time to be an adjunct professor at Paul Quinn College. So I give you Monica Purdy.
Thank you. Thank you so much for that introduction here this afternoon. I want to say hello. I am pleased to moderate this panel this afternoon for you all. I want to thank our sponsors for this particular event. You can see them listed there on your screen. It would not be possible to bring you this virtual town hall with their support. And so we are forever grateful for those that have supported this particular town hall series this afternoon. So I am going to introduce our 2 panelists here this afternoon. First, I'm going to take the liberty to introduce Tom Melsheimer. Tom is the managing partner in the Dallas office of Winston Strawn. He is described as one of the most sought after trial lawyers in the country. He has broad and extensive jury trial experience, both in state and federal courts, where he's tried numerous civil cases, which involve patents, antitrust, securities fraud, product liability, breach of fiduciary duty, and energy cases. He's also an acclaimed author of a book entitled On the Jury Trial, Principles and Practices for Effective Advocacy, written a few years ago. I ordered my copy today on Amazon, Tom, so I'll have to add that to my summer reading list. He's also tried a lot of criminal cases. So my background was in both civil and criminal, so I was pleased to read a little bit about that. But he's tried criminal cases which involve matters such as bank fraud, public corruption, copyright infringement, aggravated sexual assault, and kidnapping, representing both plaintiffs and defendants on both coasts and throughout the state of Texas. He's a graduate of the University of Texas and the University of Notre Dame. So go Fighting Irish. That is Tom Melsheimer, who's going to be our panelist today. I'm also going to introduce at this time Judge Eric Moyer. Judge Moyer currently serves as the presiding judge of the 14th District Court, a position he has held since he was elected in 2008. He has over 25 years of civil practice experience. He began his legal career with the law firm of Aiken, Gump, Strauss, Hauer and Feld, or Hauer and Feld. If I pronounced that incorrectly, I apologize. And then he went on to another law firm, Hamilton, Koch, and Knox, responsible for a broad range of commercial litigation. He founded the law firm of Vincent and Moyer, where he worked until his appointment to the bench by our then Governor Ann Richards as judge of the 101st District Court here in Dallas County. He is a graduate of Southern Methodist University and another not so known law school, Harvard Law School. That was supposed to be funny there, Judge. So his involvement in the law, I can tell you from personal experience, extends well beyond the courthouse. He spends countless hours nurturing the next generation of legal minds through mentoring and education as well as making sure our new judges have everything they need to hit the ground running from the first day that they take the bench. He does not shy away from tough cases, and he has a tremendous respect for the law, and more importantly, the role that judges play not only in the courtroom, but within our legal system as well. So we have two great panelists today that are going to spearhead the discussion about judicial independence and the importance of the separation of powers. So I am going to start by throwing out an open-ended question, and either Judge Moyer or Tom can answer the question. What is meant by the independence of the judiciary? So I know we're lawyers. We, of course, know what that means. But when somebody says it's very important that we have an independent judiciary, what is meant by that?
Well, thank you, Judge Purdy. Obviously, I'm talking to two distinguished judges here who know all about the independence of the judiciary. But let me just say, to a lawyer and to lay people, what it really means is that judges are not beholden to anyone. They do not take sides based on friendship, relationships, finances, history, anything like that. They are supposed to follow the law as they understand it, as we get it from the statutes, the common law, and then they are supposed to apply that to the facts, which are either facts that they find as judges, if they're sitting as the trier of fact, or they defer to fact findings in the event that a jury of 6 or 12 citizens decides those facts. So independence simply means that they don't read the newspaper and decide how they should rule. They don't take a poll and decide how the case should go. Instead, they make their own independent judgment governed by the law and the facts. That's how I would put it.
Okay, thank you. Judge Moyer.
You know, Judge Purdy, you're too young to remember the early 70s, but there was a judge in Washington, D.C. named John Sirica, who's a United States District Judge. And he had a case involving then President Richard Nixon and whether or not it was appropriate for tape conversations that the president had to be part of a criminal investigation over what was then the Watergate break-in. There was intense pressure that came from the White House, put on Judge Sirica to get him to agree that the president's tapes were not, could not be made available to the authorities. Judge Sirica ignored that pressure. Judge Sirica ignored the entreaties of no less than the President of the United States. And as Brother Melsheimer mentioned, he applied the relevant statutory law to the facts of that case. The consequences were not his concern. That to me is the embodiment of the independence of the judiciary.
All right. Next question. Obviously, this has been a day where a lot of people have been glued to the news, watching what has been going on around the world today. In your opinion, what would you say weakens some of the judicial independence that judges are supposed to have and that you so eloquently explained, Judge Moyer? In your opinion, what are some of the things that weakens our judicial independence?
I think the thing that weakens it the most is the attacks that the uninformed attacks that come from people who should know better. I remember not long ago a case involving a school and the president on a for-profit university, and the president suggested that because this individual was of Hispanic descent, he could not fairly rule on the case. Didn't matter that this young man, this judge, was born in the Midwest that lived his entire life in the United States, attacks, unwarranted attacks, suggesting that a judge is a liberal judge or a conservative judge, suggesting that a judge is a Obama judge or a Bush judge. Those things that unfairly undermine the credibility, a credibility that that judges have attempted not to earn just during their tenure, but every judge who comes to the bench has the benefit of the judges who came before her or who came before him, who stood up to pressures, to stood up to public opinion, judges who would do the right thing because they took an oath to uphold the Constitution and laws of the United States and of the state of Texas.
All right, Tom, what would you add to that? What do you think weakens some of our judicial independence?
Well, I don't know that I could add a lot. That was very well stated by Judge Moyer. I think that we've seen, it is helpful sometimes to look back in history and realize when judges have stood for the rule of law. I was fortunate enough to clerk for a judge on the United States Court of Appeals for the Fifth Circuit named Homer Thornberry, and Judge Thornberry was one of several white male Southern members of the Fifth Circuit that were truly some of the greatest supporters of the enforcement and support of the civil rights laws of the 1960s. They were challenged in many ways in the South, and these judges who maybe if you superficially looked at their background and said, oh, well, here's an elderly white gentleman from Georgia or from Austin or whatever, you might draw some conclusion to them that would be inaccurate because they were servants of the law. They were gentlemen who followed the law, and they did so in a way that was made them really heroes, I think, rightfully so, of the civil rights movement. And so they had lots of pressure on them. Federal judges are somewhat immune from pressure because they don't have to stand for any kind of election, although we've seen, sadly, I think a lot of pressure being put on even federal judges in the last few years and criticism. So I think that, the fact is these judges, men, women, young, old, they have hard jobs. They try to do their best. I'm not suggesting that you can't fairly critique a judge's legal analysis or say that a particular case was not well reasoned or something like that. That's fair game. But when we start attacking judges and suggesting that they have a political agenda, that's, I think, where we get into trouble. Because the truth is, if a federal judge, for example, has a political agenda, they should be impeached, right? They shouldn't be judges. And the same thing for an elected judge. If we elect any judge who has some agenda other than the service of the rule of law, well, of course, they should not be judges. But that is not the same thing as attacking a judge or saying a judge did not go for one side or the other. And I think that, when Judge Moy and I were coming out of Aiken Gump, we both started at Aiken Gump. I mean, I think it's night and day difference, the criticism that you see of these judges now. I've never seen anything like it really in my practice in the last, say, coincidentally, the last, say, 3.5, 4 years, we've seen a lot more of this than I think I've seen in my 30 plus years of law practice.
Right. One of the things that I wanted to add to those comments was I graduated from law school in 1992, and I have never seen a president speak out as to whether or not a judge is dumb or credentialed. And these are federal judges that these comments are coming from. I wanted to just reiterate your point, Tom, where you said, if you disagree with the judge's decision, that's fair game. That can be critiqued, it can be analyzed. There's a mechanism to appeal a decision that you deem not favorable for your particular client. But when you have these other branches of government commenting and crossing lanes and trying to have a case tried in public opinion, that discredits the judiciary. And puts that immense pressure that we were talking about from the civil rights area or whatever is going on during that particular time.
Judge Purdy, let me just follow up on something that Tom Milshammer just said. The Fifth Circuit, where he clerked, was, in my opinion, the single greatest compilation of judicial excellence this country has ever produced. And there's a magnificent book called Unlikely Heroes, written by a Georgia law professor, about how that court implemented Brown versus Board of Education. We were talking earlier about judicial independence. One of those judges was a gentleman named Frank Johnson. And he had, as a part of his job, ruling on a school desegregation case in New Orleans.
Mhm.
He made his ruling, and within days he had been kicked out of his country club. He and his wife went to church following Sunday, and they sat down where they typically sit, and all the parishioners got up from that side of the church and moved to the other side of the church because they didn't want to sit with him. A bomb went off at his mother's home because while Frank Johnson had the unusual at the time notion of a unlisted phone number, his widowed mother was listed in the phone book as Mrs. Frank Johnson. That was the type of pressure. That was an unhappy consequence of an independent judiciary. Dealing with as explosive an issue as we've seen in the past 75 years in this country.
I have a few questions from the chat room, so I'm going to take a few questions from people that are joining us on this virtual town hall. So anyone is open to answer it. The first question is, can you comment on the Federalist Society, what it is and why does it exist, and have judges been impeached, and if so, for what reason has that happened in the past?
I'll take on the last part of that. I'll leave it to Tom to take on the first part of that.
Okay.
The last judge that I can recall being impeached was Alcee Hastings, and he became a member of Congress. He had been a federal judge appointed by Carter, I believe.
It was. He's from my home state of Florida, so he was appointed by Carter.
I wasn't gonna put him and you in that, but he was convicted, impeached by the House, and then convicted by the Senate for the improper acceptance of funds, the bribery, basically. I'm trying to remember a judge before that. It is very rare, incredibly rare, for a federal judge to be impeached. I would bet that it doesn't happen more than once every couple of generations.
All right. And Tom, do you want to take the first part of that question? Can you comment on the Federalist Society? What is it and why does it exist?
Yeah, so I think it's interesting. The Federalist Society, in and of itself, the premise of a society that advocates a so-called originalist or original intent view of the Constitution is a pretty standard issue, conservative or even libertarian type organization. And I don't think those organizations in the abstract, there's anything wrong with them any more than there's anything wrong with an organization that advocates for a different interpretation. The problem that I think a lot of us see with the Federalist Society is it's become a litmus test used by very conservative politicians to measure judges. And if you're not a member of this society as a lawyer, then maybe you're not going to be given favorable consideration to be appointed as a judge. So I think it's the concept of it is fine. We've had original intent judges for decades. There's nothing wrong with that. I don't agree with that judicial philosophy, but there's certainly nothing illicit about it. But the society itself has become sort of a badge to show a certain political bent. And I think that is unfortunate because that's what we want to get away from in our judges. We shouldn't be able to walk into a courtroom anywhere, in my opinion, and be able to conclude after a one-day hearing, a 1-hour hearing, or a 3-week trial, what the judge's personal politics are. That would be, to me, a failure of the judge to be a good judge. So that's what I don't like the Federalist Society, because I think it's sort of a bad dog whistle, if you will, to signal to people what your views are, that I just think is not healthy.
All right, thanks. Take another question here. Question is, why is it taking our legal system so long to make a final decision on the enforcement of subpoenas to the president for his financial records? Tom, we will punt to you on this one.
Justice moves slowly. I think it's we've probably had more politically fraught litigation in the last 3.5 years than we've had in the last 40 or 50 years, candidly. I would say, Judge Moyer mentioned the great Judge Sirica. Certainly you had some cases involving the Watergate investigation and related issues that came up, but I don't think nearly the volume that we've seen in the last few years challenging various actions of the administration, as well as this question, which is the enforcement of these subpoenas. The problem is, I think, is that we rely on certain norms, a disclosure of financial information, for example, tax returns. And turns out that's not really a law. It's just what every candidate has done for many, many years. Right. And if someone said, I don't want to do it, it turns out you have to litigate that. And I don't purport to know, I'd like to see those records too as a private citizen. I don't purport to know who's right on the law. And this is the point I'm making about the rule of law. As a Democrat and as a citizen, I would love to see those records, because I believe they would show that all kinds of things about the president that the public would want to know, it would be likely many of them negative. But I'm not going to sit here and tell you I know what the law is on that. The law has to be studied and evaluated and argued, and a judge applying those principles has to figure it out. It might be the law says we don't get that. And if that's the case, then maybe we should change the law. But that's a good example of where the rule of law and what we might want as Democrats, or what we might want as purveyors of a particular point of view, there might be a difference.
And following up on that, keep in mind, as Tom has just mentioned, we are in that particular context such an uncharted area, and the question is complex, and it's not as simple as whether or not an individual was negligent in the way that he or she handled a particular job. There are two sides, and obviously with the stakes this high, you've got two groups of lawyers who are working vigorously to drive a particular point of view. And if that question is posed by the Ed who I know, who trained me a little bit, and therefore take some responsibility in what I've become, understanding how complex the issues are and how it is not, and going through the process from the trial court to a reconsideration, to an appeal, to a decision from that appeal, which may itself be reconsidered and then considered by the entire DC circuit before getting to the Supreme Court. So it is a process that has got rules and steps every portion of the process, and I kind of feel good about the fact that when a final determination is ultimately made, it will have been driven and vetted, if you will, every step of the way through the process. What we're talking about is too important for any judge, regardless of how sagacious she or he may be, to shoot from the hip and make a determination.
All right. This question is going to be for you, Judge Moye. What is the hardest part of being a judge? You have served for many years now here in Dallas and have been on the bench for, is this the fourth term?
Fourth term, yes.
Fourth term. What is one of the hardest parts about your job?
There are a handful of challenges. We very seldom get good lawyers with incredibly simple issues. If a lawyer the caliber of Tom Melsheimer is in the court, the lawyer on the other side is going to be good as well. And the issues are incredibly complex. The issues are often certainly consequential in a very large context. And there's no immediate bang, here's the right answer. The issues sometimes are framed in ways that make an answer appear to be very simple. Sometimes a brilliant trial lawyer will frame the issue in a way where the answer is much more amorphous. And trying to drill through all of those to get to the right decision sometimes is challenging, but it's such a wonderful intellectual challenge that I really do enjoy. I think the thing that bothers me the most is where there is law that is very clear and leads to a heartbreaking decision. For a case where, for example, in a foreclosure, where somebody has had a very difficult time and has a very good reason why they have not, over an extended period of time, made payments that they should. But the law says that when these things happen, there is a particular outcome. Regularly, I make decisions that if I were not a judge, but if I were just czar of the universe, I would do something exactly different. Those instincts have to be put aside because we take an oath that we will indeed enforce the law as it is given to us.
All right, next question. Do you think that Supreme Court judges should be subject to term limits? I'll ask this of Tom.
I really don't think so. I know this has been mentioned by some people I like. Mayor Pete out of South Bend has mentioned this as an idea, and I respect him, and he's as smart as a whip, but I just don't think it's a good idea. I think we're feeling that now because, we're forgetting Justice Brennan or Justice Douglas. Or Justice Warren. We're forgetting these long-lived justices that were on the bench for so long. And of course, we're not forgetting Justice Ginsburg. So the truth is, I think life tenure is liberating. I'm sure Judge Moye won't comment on this, but the fact of having to go and be evaluated every few years by the voters, it's exhilarating and it's great, and there's some good things about it. But having that lifetime tenure is kind of liberating too, because you don't have to engage in fundraising or those sorts of things, and that's why, candidly, the point he made about the unsung heroes or the unlikely heroes of the Fifth Circuit, it's precisely because Judge Johnson was not subject to election that he was able to make that decision with great courage, knowing that the worst consequence he might have is he might find himself a little lonesome at church or be kicked out of a country club. I'm not minimizing that, because some of these guys actually also suffered death threats, but the truth is, it's liberating to have that independence. So I would say I like the lifetime appointment. I think the key is to elect senators and others and presidents that will nominate and confirm the kind of judges that we think are smart, follow the rule of law, and don't have political agendas. I think that's the solution, not a term limit.
All right, thanks.
I agree with Tom. I think that for every judge that you wish was gone, regardless of your political bent, you can probably come up with 2 judges who you believe made brilliant decisions well past the time when most of us are thinking about hanging up the spurs.
All right. I have a question here. It's a little bit about Dallas history, and I'm going to pose this question to Judge Moyer because I know you used to represent Dallas Independent School District. Was Judge Fairfax Sanders in charge of helping to integrate Dallas Independent School District? I am trying to remember the circumstances. Question comes out of Irving.
Sure. He was involved. He was not the first judge involved. I believe it was Judge Taylor who first had the school desegregation case, which went on for more than 20 years. Judge Sanders took that case over when Judge Taylor retired and administered over that case for almost at least 15 years himself. And through the time when the district was ultimately declared to be unitary, i.e. no longer segregated.
All right, another question. Do you anticipate Congress enacting a law to require presidential candidates to produce their tax returns in the future?
I don't know. I wouldn't think so. And if they did, I'm not sure that would survive a constitutional challenge, because Article 2 of the Constitution sets forth the requirements to be a president. And I think a compelling argument could be made that this is an attempt to expand by a law of Congress a provision of the Constitution. And so if, for example, Brother Melsheimer was running for president and refused to disclose his tax returns, and one state decided they were not going to put him on the ballot, an argument that he could make that says, I'm qualified because of what the Constitution says to run for president. That would be an interesting argument to make. So I don't think that that's going to be something that will be resolved by, no pun intended, an act of Congress.
All right. Next question. What is your opinion as to whether or not judges should be elected here in Texas? I know this virtual town hall, we're talking about separation of powers. We have an executive branch, they do their job. Legislative branch does their, and the judicial branch performs their job. But we know that there has been some legislation that has been introduced, and it is questioning whether or not judges in Texas should be elected. There's lots of different ways around the United States that judges can become a judge. Some are done without being elected, and some are being done by the appointment process. So just would like to hear your opinion as to whether or not you believe judges should be elected, appointed, and just the argument now that there's some legislation that has been introduced in our Texas legislature that basically says we think that judges should not be elected in our state.
Well,
I'll just toss that out there.
Let me say this. So Chief Justice John Hill of the Texas Supreme Court was a brilliant guy and a really good judge. And he, for many years, was working on different ways of selecting our judges. And so someone as smart and as good-hearted as John Hill, he had some views that were not exclusively to have judges elected. So I think it's a fair argument to have. I think that the idea of having some check and balance on the judge is useful. I think that there are negatives to it as well, because you could have a judge who makes the right decision on the law, but it's unpopular. And then he's got, he or she has got a campaign opponent running on that issue. That's kind of unseemly to me. But I think that on balance for Texas, I think elected judges are good. And I believe that the key for everyone on this call and to sort of populate this idea among people who aren't, is it's important to have a strong Democratic Party, because the party can be very actively involved in making sure there are good candidates that are put forth for election. As we all know, and one of the underlying premises of this question is that, well, people don't know the judges. They're voting on people they don't know. Someone could be a great judge or could be a very weak judge, and no one knows, or maybe their name is different, or they're more appealing, or maybe it's whatever it may be. And those aren't good reasons to pick a judge, right? But that's why I think the party, if you're going to have elected judges, I think you have to have a strong party influence on the process of making sure that the judges that get put forth to the electorate are in fact capable and good judges. No doubt we have more lawyers who would be qualified and excellent judges than are running. So it's not that there's a shortage of candidates, but I do think that some of this frustration comes from the idea that we don't know the judges, and there's this unseemly process of raising money and things of that nature. I generally think we ought to stick with what we have, but I think it's important, it's incumbent upon the party, the leaders of the party, and for the voters to educate themselves about who these people are.
I think I get to the same point at the end as Tom does. I go a little bit of a different route. When you move from an elected to an appointed system, you're changing your politics from retail politics to wholesale politics. When I'm running for Judge Purdy, as you are now finding, as you run for a judge, one of your challenges is to meet as many people as you can, as to expose yourself to as many people as you can, to get in front of as many audiences as it's possible, to get them to the point of determining, this is somebody, I want to vote for this Monica Purdy. When you have an appointed system, you compress all of that into, rather than you're meeting 500 people at a sorority meeting, or meeting 1,000 people at a church, or 100 people at a social club or a political club, you distill that, you compact that down into you're meeting 3 or 4 people who have influence, either by institutionally being a part of a committee that the executive uses to select, or who have influence on that committee or the executive herself or himself. So to the people that say going to an appointed system will take the politics out of what we're doing, I'm not sure that that's 100% correct. What it does is it shifts the politics from a place where it's exposed to, excuse me, a large number of people, to a very small, a much smaller number of people. The politics remains in the system either way. And also Texas has a well-deserved and earned reputation as being a very populist state. I think people, I hate to generalize about all Texans. I think Texans kind of like the idea of deciding who their representatives are going to be at the judiciary and at all levels. And I think it would be one heck of a fight to get Texans to give that up.
All right, thanks. Another question that I have, this is for both of you all, you can answer this. What is the funniest thing that you have observed in a courtroom?
Well, Well, I would say this. I observed in the Fifth Circuit when I was a law clerk. I observed a lawyer who was asked a not a particularly challenging question, but it was a question. He was a young lawyer, and he was asked a question by one of the more senior judges on the court in a very deep baritone, almost kind of a Morgan Freeman voice of God kind of thing. And the fellow just completely lost his composure and grabbed onto the lectern and fainted backwards. And so I hesitate to tell that story. I might say who it was, but it's not really funny. Okay. I mean, it wasn't funny for him, and it created quite a commotion, as we would say. But that was one of the more unusual things I've seen. And I would say the other thing I'd say is I once, this will show my age, but I once cross-examined Dick Clark. Remember Dick Clark from American Bandstand?
I do. American Bandstand.
He was a character witness in a case, and I didn't really have anything to ask him on the prosecution side, except I did ask him under oath, how old are you really? And that drew a fair number of laughs in the courtroom, and he was well into his 70s. He answered truthfully, but so that was, that was funny.
Judge Moyer.
We had a case going on in my court, a commercial case several years ago, and a witness got on the stand and just testified brilliantly. I mean, he was upright, he was stern, he was empathetic, answering questions with great precision. The cross-examination went on for about 10 or 15 minutes, and obviously guy was just unflappable. And one of the lawyers handed the lawyer inquiring of him a note, and just at the lawyer note, and the lawyer asked the question, all right, Mr. Johnson, isn't it a fact that you owe, that you have a debt from the party in question of $250,000? And the man on the witness stand sat there for half a second and looked over at me and just shook his head no. He said, yes. And the jurors just, in 1 second, this guy went from being a witness who seemed to be unimpeachable, with no dog in this fight. And when he was asked a question, you could just feel him just kind of shrinking up a little bit, and then all of a sudden just answering truthfully. And the one question that ended up destroying all of the value of that testimony.
All right, another question, it kind of piggybacks a little bit off of our previous question that talked about limitations on our Supreme Court justices. This question is, what about limiting the Supreme Court justices to a maximum of 20 years without the need for going before voters? This way we get fresh blood and keep up with changes in society and technology. So as opposed to a lifetime appointment, what about appointing them for a 20-year period of time?
If you look at a justice like one of my personal heroes, William O. Douglas, who came onto the court as a relatively young man after the New Deal, and stayed on the court for almost 40 years, if my memory serves. When he started as earning the nickname of the Great Dissenter, and over the span of his multi-generational career on the court, became the voice for the great liberal wing of the court into the 1960s, into the 70s actually. If he had, well, you left the court in the 60s. If he had been limited to a finite term of 20 years, we may not have had some of the guidance from him and his judicial opinions that we found. The challenge with something that is arbitrary is because it's so arbitrary. There may be some justices that you say, thank God you're counting off the days on the calendar until Justice so-and-so is gone. But on the other hand, you lose the value. And Justice Douglas became a more brilliant justice, in my opinion, the longer he served on the court. And I think we'd be a poorer society without having that.
And something I would just like to add to that, certainly Justice Ruth Bader Ginsburg, she is just superwoman on that particular court. And I definitely would not have wanted to limit her knowledge and wisdom that she imparts on a daily basis to just 20 years. I think she just gets better with time each year. So I would add that to that particular remark. I'm going to ask one more question of our panelists, and then we're going to have some closing remarks from you all. We started off talking about the separation of powers, why it's important to uphold judicial independence. I want to ask each of you all, what are your recommendations, if any, to protect judicial independence? What are things that a lot of people on this call who are voters, who are common individuals, who are concerned about the rule of law, what are some recommendations that you may have with respect to ways in which we can protect judicial independence? And I was thinking about, of course, bar associations play a huge role, lawyers play a huge role, because those are the people that are before these judges that can, of course, communicate to the general public their opinions about a particular judge. We have open courts, even though we are in the midst of a pandemic and there are virtual hearings that are going on, they are still open. There's YouTube channels where you can get on and live stream. We want to make sure that we are transparent and that people are able actually to access our courts and get to our courts. I think another way in which to protect judicial independence is to ensure that we always have diversity and inclusion on that bench, so that when whoever may walk in with a particular issue knows that they are going to have justice served to them. So just your thoughts as to ways in which to protect judicial independence.
It's like protecting our democracy. It takes work. It takes hard work by everyone who is invested in it. Dallas County, like Harris County and Travis County and Bexar County, we have too many judges for an individual to decide to wake up on the morning of election day and decide for whom one is going to vote. We really need an educated electorate. Those of you who are listening to this are what Bob Strauss used to call inside baseball folks. You already care about these issues, and probably most of you listening to this have a good idea of who your judges are and which ones you are going to support. Talk to your colleagues, talk to your neighbors, talk to your coworkers about that experience. When we reopen, spend some time at the courthouse. See, if you can, see what the people who are vying for your votes do. You have to be educated, particularly now that we no longer have the straight ticket voting. Whereas before you could go in and press one button and vote for all of the Democrats or another party if you were so inclined. Now you've got to vote all the way down ballot, and you don't want to get into the voting booth and see two names and not having done any research and not knowing anything about them. It just takes hard work.
All right, Tom?
I've used this analogy before. I think, everybody needs to become a lobbyist. And what I mean by that is this, there's a gun lobby. Okay. There's a pharmaceutical lobby. There's not a lobby for judicial independence. There's not an organized group that has the power and sway of the NRA or big pharma. But that doesn't mean that individual voters, whether they be lawyers or not, or no lawyers, or have lawyers as neighbors, or have no contact with the law at all, doesn't mean that they can't be lobbyists for the importance of judicial independence. And I think that if we talk about it, we talk about what it means. You know, people give opinions about cases. Oh, that judge made a crazy ruling. You know, ask your, well, do you really, do you know all the facts? Had you read the law? Do you understand the different competing principles? I mean, those kinds of things we need to be pushing back on against criticism that is, I understand people get angry and frustrated, but they need to be fact-based. And so I think we as informed, educated people can do a lot to educate and let people know, hey, there's another side to that. There's some information that you may not be aware of. And just doing that, I think that's a ripple that can cause bigger ripples, that can cause a wave that really will be in support of what we treasure so much, which is our judicial independence.
All right. Well, we're going to have some closing remarks. I'm going to hear from Judge Moye, and then Tom, I'll let you close us out. But I do want to thank our sponsors again for allowing us to put on this virtual town hall. I believe it's a very important topic that everybody needs to stay abreast of. I think as Carol mentioned in the beginning, I have a 7th grade son, and in history, we were talking about the importance, why everybody needs to understand how our government works. So I think it is a very important topic, and I'm glad to be asked to have moderated this afternoon. So Judge Moye, any closing remarks that you might have?
Sure. I want to echo the thanks to all of our sponsors for making this happen. I also want to thank all of the viewers who are out here watching and listening to this. The good Lord has really blessed me in a number of ways, and one of them has been the ability to travel. And I've traveled over about 2/3 of the world, and everywhere I go to courthouses. And I want to see, even if my French is not good enough for me to understand all that's going on in the Palace of Justice, but I want to go and see and watch how they do what they do. And I've done that in Africa, and I've done that in all of Western Europe, and I've done that in Asia. And the thing that has stuck with me is that nobody does this as well as we do. Because we have citizens who play a role in our system of justice. And when I talk to judges from other places who ask me, how is it that you can let citizens play such an important role? My answer is really simple. How can you not? Juries get it right more than they get it wrong. Juries also give people the belief that they have someone who's listening to their grievances or their defenses, whether they win or they lose. There's something very cathartic that comes with talking to a jury. We have an independent judiciary that I am incredibly proud to be a member. We have a system that sets the judges apart from the legislature, sets us apart from the executive. We are not to intrude on one another. And when it happens, the circumstances are almost invariably bad. Our system lets people have access to an independent fact finder, being jurors, an independent applier of the law to the facts. I like telling the story that an incredibly litigious group over the past several years has been the Hells Angels, because they're protecting their trademarks. Our system of trial by jury is so forceful, it makes this motorcycle gang act in a civilized manner, which is how they resolve their disputes. That's extraordinary. It doesn't happen anywhere else. And all of us should fight to our dying breath to make sure we continue to have this.
Thank you. Tom?
Well, this is why performers say, I don't want to follow Meryl Streep or Morgan Freeman on the stage. So I'll just echo that Judge Moye talked about being blessed for this travel. I think we're blessed to have judges like Judge Purdy and Judge Moyer on the bench. And the truth is, learning more about these good judges and telling your friends and neighbors about what makes a good judge is probably some of the most important work that folks can do locally, because it is an area where people feel uninformed. I don't know all the judges. Like, I'm not in the state criminal courthouse. I'm not in the family courts, thank goodness. And you know, I don't know those judges. So I try to find out about them and what people think about them. And when I hear something good, I'll repeat it if it's from a respectable source. So I just say, keep on spreading the good word. And Judge Purdy, thank you for having me on this. And Carol Donovan, thank you as well. And we're blessed to have both of y'all as two fine examples of independent judges.
Well, thank you. Thank you so much again. Thank you to our sponsors. We are wrapping up right at that 4:29 hour. We were going to keep you for an hour. We stood on our word. So we just appreciate you all being with us this afternoon, imparting such wisdom and knowledge, and letting everyone know the importance of keeping our judiciary independent. So it is appreciated. And I guess I will turn it back over to our chair, Carol Donovan, at this time, or Josh, or whoever's going to end us out.
I think we're going to leave it to you to close us out, Judge Purdy. You're the one. Take us home now.
All right. Well, I think Carol is muted there, but as I understand, these virtual town halls happen every Friday. So Carol will let us know when the next one is planned and the topic. Have a good weekend. Be safe. Continue to flatten the curve, and we're going to get through this pandemic, and just appreciate you being here. So thank you very much. And that concludes our virtual town hall. Take care.
Thank you. Bye-bye.
Bye-bye.